Good morning, good afternoon, and good evening, everybody, and welcome to the last in this year's Administrative Law and Governance Colloquium series. My name is Paul Daly. I am the University Research Chair in Administrative Law and Governance at the University of Ottawa. Our topic for this year's colloquium has been the legitimacy of the state. The legitimacy of contemporary liberal democratic states is in a state of flux. Managing the effects of globalization, responding to the COVID-19 pandemic, and fighting escalating inflation have prompted serious questions about public administration in the global north. These pressing issues have shone a spotlight on difficult areas for liberal democracies, which have struggled in recent decades to reconcile popular desires with the need for effective governance. In this year's colloquium, speakers have addressed challenges to legitimacy in liberal democratic states by focusing on the executive branch, the civil service, administrative agencies, and immigration policy. And today we're going to look at central banks. The overall goal has been to outline contemporary legitimacy challenges and likely responses. My guest today is Professor Peter Conti-Brown, who is the class of 1965 Associate Professor of Financial Regulation at the Wharton School at the University of Pennsylvania. He is also the co-director of the Wharton Initiative of Financial Policy and Regulation and non-resident fellow in economic studies at the Brookings Institution. His research interests include administrative law, central banking, financial history, financial regulation, fiscal crises, political history, public finance, and the Federal Reserve. He's the author of the book, The Power and Independence of the Federal Reserve, Princeton University Press 2016, which was my principal reason for inviting him on as a guest, and is also co-author of many texts on, author and co-author of many texts on financial regulation and central banking, including an important article in the 2021 Yale Journal on Regulation called Towards an Administrative Law of Central Banking. Peter, thanks for taking the time to discuss central banks and legitimacy with me. I guess I'd start off with a softball. Is there ever a time when it is not interesting to be a scholar of central banks?
You know, it's so funny that you asked that. Just this morning, I'm finishing in the next 3 weeks a major, 220,000 word political history of the Fed, which I'll submit to my publisher. And I'm just going over the section on the Great Depression and found this wonderful editorial that said, most of the time we don't pay much attention to the Federal Reserve, but now it seems to be on the lips of everybody in every corner deli shop. And I've said a version of that sentence so many times since I started my scholarly efforts in this space in 2007. And I think I'm ready just to declare it's always interesting to be talking about the Fed. There's never a time in its history when it wasn't at the very center or in the shadowy periphery touching the center of our political life and our social life. And indeed, that's really the thesis of my next book is understanding the politics of the Federal Reserve, not the partisan politics so much, although there are plenty of episodes like that, but understanding how the Federal Reserve interacts with other political actors deeply embedded into political frameworks and political institutions. Because the reality is that the Fed, through incredible crises, through incredible triumphs, has had a one-way ratchet of increased power and authority in greater and greater areas. I don't see this in the same way that some Fed critics see it as a nefarious conspiracy or something that should alarm us. I think of it as a fact of political life that central banks, for reasons that have to do with their epistemic communities, for reasons having to do with how fiercely they defend the idea of legitimacy while still incoherently defining it, they have walked an idiosyncratic path that they continue to walk today. And even in the midst of what I would regard as something of a supervisory scandal at the Fed in 2023, I fully expect, indeed I advocate, for the Fed's supervisory discretion to expand. And I don't know of another institution quite like that, where you see even in periods of triumph and in periods of scandal, the expansion of the portfolio. But that's indeed the story of the Federal Reserve over its long history. That's my long answer to your short question. The answer is, my short answer is no. There's never a dull moment in my lifetime, and indeed as a historian, as I look throughout the Fed's lifetime, to be thinking about its effect on policy and politics.
Yeah, as you may have guessed, those who are tuning in, we're going to structure this as a conversation between me and Peter mostly, but it is a conversation that's open to others. So in the Q&A box, if you have a question that you think Peter can answer or should answer, just drop it in. I guess on the question of the Fed's mandate. And I mean, I think this is your work is about the Federal Reserve, which is the U.S. central bank. But I think there are many aspects of it which resonate in other comparable jurisdictions, Canada, United Kingdom, for example. I guess what strikes me from your book is that the mandate of the Federal Reserve and other central banks hasn't been static at all. And sometimes in the popular imagination, we think of the central banks, inflation, and that's what they do. But that's not the case at all. And it has actually shifted and expanded dramatically over time.
Yeah, that's exactly right. It shifted, it's expanded, it zigged, it zagged, its interpretations have shifted. You know, one of the key insights from political science that has really helped me understand the role of central banks in the US and elsewhere is this idea of deliberate discretion, this idea that when Congress writes statutes that are open-ended, it's making a deliberate policy choice. And sometimes that's a policy design choice. Congress, in its coalitional consensus, has decided that the problems require the application of discretion. And sometimes that's a function of coalitional compromise. We cannot agree on what the central bank should do, and so we open it up for those politics to live and die another day. And the Fed's history with its quote unquote mandates illustrates both phenomena. And on the one hand, Congress did have a remarkable degree of consensus that the Fed should promote financial stability. It didn't use those terms in the statute, but it effectively did. In 1913, and expanded through a series of amendments from 1927 through 1935, and on and on. And Dodd-Frank is the most important of these in the 21st century. And then other times we see Congress just can't figure it out. They know there's a problem to solve, and they feel in their bones that the Federal Reserve is the one to solve it, but they can't agree on even defining the problem or in articulating the solution. And so it gives the Fed very broad, sometimes inconsistent mandates and says, please go figure this out. Macroeconomic stability is the most relevant there. Now, you'll note that I didn't mention price stability, and I didn't mention employment stability, or sometimes what we call maximum employment. And that's because the idea of a dual mandate at the Fed of price stability and maximum employment, it does exist in the Federal Reserve Act, along with a third, moderate long-term interest rates. But that's only a very small part of the Federal Reserve Act. The rest of the act is filled with mandates of various kinds. And other central banks the world over have a stunning variety of mandates. And so what's useful is to get past what central bankers have themselves described as their mandates, sometimes giving preference of one over another, and look instead about, what did Congress give as the Fed's mandate? And there we have a much broader sense. Where we're seeing some really fascinating interplay in 2023 is the fact that we've got appropriate political pushback on the aggressive monetary policies of the current Fed, hiking 475 basis points in the period of 12 months, worried about the implications for employment that such aggression could have. While simultaneously, Congress has given the Fed its oldest mandate of financial stability to be operationalized through bank supervision and regulation. And here, the Fed just completely dropped the ball. the Fed decided that the inflationary environment of late 2021 required an aggressive response, and that the aggression of that response, the speed of those interest rate hikes, continued to accelerate through 2022. What Jay Powell said in his most recent press conference was, the bank shouldn't have been surprised by this. It was in a lot of newspapers. I'm paraphrasing, but it was the idea. And he says that tongue in cheek. He's just like, listen, we weren't secret about the fact that we were doing this. Why didn't the banks succeed in changing their affairs? Because, to be clear, the Silicon Valley Bank failure is a failure that has several pretty basic problems in it. But at its core, it couldn't meet the incredible demands from its funding, its deposits, because it was so overexposed to low interest rate, relatively safe assets. Now, other banks were not so exposed because they did adjust their assets relative to the Fed's interest rate policy, but Silicon Valley Bank did not. And Powell is grumpy about this. Why didn't they? He doesn't want to be blamed for this because he doesn't want financial instability implications for monetary policy. But the Fed, of course, owns this. It's not enough. We don't do bank supervision by writing central banker projections into the newspaper. We do bank supervision as a major mechanism of financial policy behind closed doors in private conversations between the government and banks. And it reminds me, to hold the Fed harmless because it announced what it was going to do would be like, if you've got a third grade teacher who takes 30 kids on a field trip and is really clear with all 30 of those kids line up at the bus at the end of the day and comes home with 28 kids because 2 weren't paying attention. We wouldn't say to that teacher, well, yeah, you got 28 of the kids back. We'd fire that teacher, right? You've got to take extra concern with some of the laggards. And the failure of Silicon Valley Bank belongs to its bankers, but also belongs to bank supervisors through the use or misuse of the Fed's own management of its mandates. So again, I'm giving you long answers to your short questions, but that's how those mandates become so important and create so much discretion in the Fed's implementation of them, and why here personnel is policy in a pretty extraordinary way. Not just in the banal sense that we use that adage, but in a very direct way, because Congress has given so much to the Fed to do. His legislatures do this for central banks everywhere. The people we put in these seats of power prioritize, and those priorities become policy themselves.
That's very good, and I can see there are some questions already in the Q&A, but I just want to ask Peter about the another aspect of the institutional relationships that the Federal Reserve has. So you've talked about the mandates it gets from Congress. What is there to say about the relationship between the Fed and the President? Where does the Fed sit in terms of our normal taxonomy of separation of powers, and what influence does or does not the elected president have on the direction the Fed will take in relation to policy and the execution of those mandates?
The Fed illustrates kind of the story of administrative law's legalisms, its formalisms with respect to agency independence and separation of powers concerns the Appointments Clause, for example, in U.S. constitutional law. So quite from a formal perspective, presidential control over the central bank looks a lot like presidential control over other agencies. We have a board, in some ways, we have a board structure, one of whom is designated as chair. Each of these has to be appointed by the president and confirmed by the Senate, the chair separately. That's the trivial version, and it's so trivial as to tell us virtually nothing, because here's where it gets complicated. The Fed chair that the president appoints is only to chair the Board of Governors, and this is the authority over regulation and supervision. A separate committee, the Federal Open Market Committee, which conducts monetary policy, also has a chair. By tradition, they elect as their chair the person the president selected, but they don't have to do that. It's by a vote that's taken annually. They could choose any member of the Federal Open Market Committee, which consists of those 7 governors the president is appointed, plus a rotating cast of the presidents of the 12 Federal Reserve banks. One of whom is always New York, the other 4 rotate from the other 11. And that mishmash, and who are these presidents? Those presidents are appointed by, we don't quite know. The Federal Reserve Act creates a classified board structure. Classes are 3. The 2 of those 3 classes vote to appoint a president, but that's subject to a veto by the Board of Governors, who also appoints one of the classes of directors. Now, if you're confused by now, welcome to Federal Reserve governance. Federal Reserve governance is a mess. It is not designed to be clear. It was overhauled in 1935 to be clearer. Before 1935, and what I call the first Federal Reserve System was essentially a set of private banks, much like J.P. Morgan Chase and Citigroup and Wells Fargo, given the ability with special privileges to conduct the nation's financial policy, but also with an eye to their own profits. That was mostly abolished in 1935. We kept some of the names as the same. We changed some other names within the system, and that created our hybrid system that we have today. What can the president do about this? He appoints those people on the Board of Governors. And what more he does about this is then subject to norms. Former President Donald Trump, no fan of governance norms, sort of bulldozed through them. 3 norms that he broke, some of which with bipartisan approval, some of which with bipartisan opprobrium. The first norm was he did not reappoint Janet Yellen, the sitting Fed chair. This breaks a norm that was very old, going back to the 1950s, where presidents would conventionally reappoint the central banker installed by his predecessor, a norm that Joe Biden reinstituted. Another norm that he broke was what I've called the Rubin Rule, named after Bob Rubin, who was the Clinton Secretary of the Treasury, and before that he was the first director of the National Economic Council under Bill Clinton. That's the chief economic advisor to the president, although there are some others who might see themselves in that role. And during that time, after a very hostile relationship between George H.W. Bush and Alan Greenspan, the Clinton White House created reinvigorated a tradition that had been started by Dwight Eisenhower, but quickly abandoned by his successors, never to comment on individual policy decisions of the central bank. Again, Nixon and Johnson and Carter and Reagan, and especially George H.W. Bush, they commented quite sternly. And George H.W. Bush, in the State of the Union address that he gave in 1990, excoriated the Fed and told them to lower interest rates from the floor of the Congress. But for Clinton, Bush, and Obama, they retreated into this idea of not commenting, giving up a major part of their authority in favor of grabbing onto the political legitimacy of the central bank. So they were hoping legitimacy would go the other way. Not elections legitimizing the bank, but the bank's technocracy legitimizing politicians. This is a particularly important thing for Bill Clinton, because he did not win a majority of the vote. He won 42% in a 3-way race. And so Trump abandoned this. Biden has reinstalled it. And the last thing that Trump did to avoid those norms, and again, this is all of Trump's norm breaking, meant that the central bank was closer to the president. He wanted to pull it closer. This was self-conscious. In fact, something I've never told anybody before, I had this a quite fascinating experience. I'm not a Republican, and I had written publicly about my in critique of Donald Trump's policies towards the Fed. But the Trump White House reached out to me during this time to ask me, after reading my book, to help them design a way that the president could control the Fed better. I heard them out, but I didn't participate in it. But that was such a fascinating and honestly such a thoughtful way to put institutional design on what their attitude was, which was quite simple, and with which in the abstract I'm quite sympathetic, which is, who elected these technocrats? Now they're zagging when we want them to zig. Aren't we the ones with the electoral mandate? They're not obviously wrong in every respect, and they're not obviously right in every respect. But what the last thing that Trump did was he tried to install basically unqualified cronies to the Fed's Board of Governors. This failed. The norm held up in the Senate, but just barely, mostly because 2 Republicans got COVID in the last minute. And so then Vice President-elect and still sitting Senator Kamala Harris rode in a midnight train from Delaware to cast the tie-breaking vote against one of those cronies. And so it's a jump ball is my answer to this. The formalisms that the Supreme Court pays most attention to in separation of powers jurisprudence are awkward within the Fed. It's not obvious how those work as a matter of constitutional law. I take the view in the book that I don't think they work at all for the Reserve Bank presidents who, after 1935, do not, even though they keep their private sector status, they are using the powers of government. This is not a principal versus inferior officer argument, though I think that's an interesting one too. Is more to do with whether or not the removability insulation that exists in the Federal Reserve Act it conforms with separation of powers and appointments clause jurisprudence as the Supreme Court has articulated it. But I think that most of those arguments are a bit of a red herring. Most of the action in political accountability, presidential control over central banking, will be entirely up to the identity of the president and the identity of the central bankers.
Leading on from that, one questioner asks, in what ways have central banks over time been conceptualized as constitutional institutions of similar standing in terms of power, influence, or discretion as the other 3 canonical branches of government? Maybe you've already answered that question. It depends on norms rather than, but even then, norms can be constitutional in nature, and even when norms are broken, they can still be constitutional in nature, and there can be sanctions for their breach.
That's especially true in common law traditions. I think that's less true in the United States. The consequences, I wouldn't call the consequences of the breach of norms to be little c constitutional, just highly political. I think they're political prices to pay for either upholding a norm or breaking it. Indeed, Biden paid a price for restoring the political norm of reappointment. Many on his left, Elizabeth Warren was the champion of this, absolutely detested the idea that we would reappoint a Republican to the most important economic policy office in government after the Democrats won the 2020 election. And you can, that argument it makes a lot of sense for political legitimacy. But if we were to think about legitimacy in the classic Weberian framework of political versus legal versus social, it's not obvious that legitimacy for the central bank has very much at all to do with politics, even though that's, I think, the strongest articulation of legitimacy in a democracy. But the question that comes about the constitutionalization of central banking, I think, is really interesting in a comparative, from a comparative perspective. There are jurisdictions, most notably Europe, where the central bank does achieve constitutional standing by the ratification through, in Europe's case, a treaty that can't be abrogated by legislatures after an election. Chile is another example of this. There are a lot of others where the central bank is given constitutional standing. And if I were to put my constitutional theorist hat on, I think that the general separation of powers arguments that arose in the 17th and 18th centuries, informed by Montesquieu and Jefferson and others, I do think that banking sits as a kind of separate institutional bottom from the legislative, executive, and judiciary. I think that that's probably true for banking in the 21st century. I think it was definitely true in the 17th and 18th centuries. That was just a different set of functions that you can only torture it to make it fit as a legislative or executive function. It is a little bit of both of those. It has some judicial flavor, but mostly it's just a banking praxis, and importantly, a central banking praxis. I qualify it in the 21st century because I think more and more monetary policy looks like other forms of economic policy, and certainly bank regulation looks like other forms of legislative, judicial, and executive functions. But I think there's a pretty strong case to make from a theoretical perspective that central banking is a separate pillar, maybe a fourth pillar. And the accusation that central banks have been a fourth branch of government arose first in the progressive era and accelerated, and now is relatively mainstream. It is sometimes glibly said that Congress could end the Fed tomorrow. And I say that is both factually true, but also glib, because I do think that the Fed has reached a kind of little c constitutional space within our government. And this is going to be something really important to watch for administrative law scholars as the Supreme Court continues to take up its assessment of how the administrative state in the 21st century fits within its highly originalist take on what government should be. Because unless you make very bizarre equations between the modern Federal Reserve System and the first bank of the United States, you've got a very hard case to make that the administrative state is unconstitutional everywhere but the Federal Reserve.
Yes, well, the American, the U.S. Supreme Court has, I guess, since 2010, and that was part of the fallout of the financial crisis and the response to that, has been very interested in whether people are properly appointed and too insulated from presidential control. Now I have a series of questions in the Q&A, and I'm trying to figure out if there are interrelationships between them, or what's the logical question to pose to you in the sequence we've been working through. I think I'm going to take this one from an anonymous attendee who asks, is there sufficient cognitive diversity or difference in thinking between regulatory government agencies and bankers? The latest crisis seems to indicate regulators devise tests and requirements that are not sufficiently independent in anticipating different problems than the banks do. And there was a question as well earlier about the Federal Home Loan Bank system, and which provides liquidity to community banks without the oversight of the Fed's discount window, and that Silicon Valley Bank, which you mentioned up front, and Signature took billions in advances from the Federal Home Loan Bank system advances before failure. So those are maybe one fairly specific question about policy and one general question about policy failure, and perhaps you have some reflections on either or both of those.
Both of them. I've thought a lot about both of those questions. I think that the question about cognitive, what I would call probably groupthink, is interesting. I thought the question was going to go to a different direction. Is there too much groupthink within the Fed that central banks don't see the world with adequate texture and nuance or heterogeneity such that they herd in one direction? I think the case to be made there is extremely strong. I think the idea that we want the central banks and banks to see risk and reward differently is harder. We certainly want them to be participating in the same language. They have to. Bank supervision, as I argue in a paper that I've just posted on SSRN, that's turned into a book with my co-author Sean Bonata at the University of Glasgow. It's a history of bank supervision. We argue that bank supervision is the category of government power that sits at the residual of financial risk. It is a shared risk management portfolio across the public-private divide, where the ultimate owner, it's not a perfect partnership, the ultimate owner of that residual risk is the government. And bank supervision is the implementation of that risk management strategy, including when the risk is realized on the downside. And so we need banks and bank supervisors to see the world in enough overlap that they can make policy together, because that's indeed what bank supervision is. I don't think SVB undermines that, because the risks that SVB took are so elementary, are so bad, and are so boneheaded that bank supervisors would have immediately seen them, would have filed reports highlighting them. And then where we had a supervisory failure was that they just kind of sent those reports into the ether. They didn't follow up on them. They didn't make sure that the changes were implemented. We know that the bank supervisors did that. We know that they filed reports. We haven't read what those reports are. We expect to be able to read excerpts of them on May 1st, which is when the Fed has announced that it will disclose some of its findings. And so what we didn't have is the Fed saying, oh yeah, there's no problem here. They would have definitely said there's a major problem here. What's more alarming to me is the fact that that more didn't happen, and that Silicon Valley Bank, purportedly a very well-managed bank before this crisis, could have taken such breathtaking and uncompensated risks to itself, to its uninsured depositors, to its shareholders, and ultimately to the entire system. So I think that's kind of how I see it. I don't see it as much a problem as groupthink as the fact that any thinking banker or bank supervisor should have, and likely did, raise alarms about how elementary this failure is. This is not the 2008 crisis, or those of you who are tracking that closely. We were constantly, Googling what on earth is a naked credit default swap, and understanding, collateralized debt obligations cubed, and equity tranches, and things that just weren't a part of our basic banking vocabulary. And that was the panic, in a word, because nobody knew who owed whom what by when. That is not this crisis of 2023. I think the folks for whom this is the banking crisis feel a little bit abused, because this is such a boneheaded banking crisis. It's such elementary risk. It's the second question that a bank supervisor would ask on both the liability and asset assessments. On the asset side, how are you managing the incredible deterioration of your securities book? And on the liability side, your ratio of uninsured to insured depositors is 22 to 1. We think that anything above 5 to 1 is deeply problematic. And that's these are questions that were asked, they just weren't answered. Now, remind me, federal home loan banks. How should we think about that? There's the second question, Paul. I'm so glad for this question. The federal home loan banks were created by Herbert Hoover, who sometimes gets a bad rap as a stand-pat president. In the face of crisis, we did have a stand-pat president like that. His name was Calvin Coolidge. He had an allergic reaction to any kind of governmental participation in not just the private sector, but in crisis. They're very famously, Hoover, who was Coolidge's Secretary of Commerce, during a time of massive floods in the 1920s, with real exposure of death and poverty to those afflicted in the Mississippi Delta. Coolidge was like, yeah, well, did they have private insurance? No, then that's on them. Let their families take care of it. And Hoover said, no, we're going to do something about this in the Coolidge administration, even though it had nothing to do with the Secretary of Commerce. Hoover was a grand experimenter. And he tried so many different things in the 1920s and during his presidency from 29 to 33. And one of them was the federal home loan bank system. As originally conceived, there would be a federal home loan bank in every Federal Reserve Bank district. There were some changes there, but there are still 12. And the idea was to dramatically expand support for a very specific kind of asset in the hope of resolving the Depression. As it happened, support for that kind of asset, it's just too lagged a return, and so it couldn't give the immediate relief. But it's not an exaggeration to say that our economic policy for the great middle class in America is built on the 30-year mortgage, and the 30-year mortgage is built on the Federal Home Loan Bank system. That's as it was conceived in 1932. As it's evolved, it's something different. My colleague Kate Judge at Columbia has described the Federal Home Loan Bank system as the lender of second to last resort. We don't have a good theory about what on earth it's doing there, but it does come into pretty important relief with crises because of the relationship between the Federal Home Loan Banks and the Federal Reserve Banks with respect to this kind of intermediate stress lending. Federal Home Loan Banks take out a blanket lien on all collateral. So when you've borrowed $20 billion, as Silicon Valley Bank had done, then the Federal Home Loan Bank of San Francisco has a claim on the entire book of assets. But the discount window through the Federal Reserve Bank operates differently. You pledge specific collateral, and that can be all the way down to a single security, but more conventionally, it's to different parts of the book. So you can say, we're going to designate the following billions of dollars of assets of these kinds of securities for collateral at the discount window. And those conflict. And they require the Federal Home Loan Bank, which has a first lien, a blanket lien on all of these assets, to sign away that lien for specific assets pledged at the discount window. Now that happens in a well-run system only when it's worked out ahead of time, even before the lending has occurred at the discount window. Silicon Valley Bank had an easy time gaining access to tens of billions of dollars from the head of Federal Home Loan Bank. And in the weekend of its failure, had a very, very hard time positioning itself at the discount window because it had to work out those conflicting liens, which the Fed will not loan against until that workout is done. And they hadn't done it ahead of time. Now, I blame Silicon Valley Bank bankers for basically everything. I think that there is zero excuse for the way that they behaved in mismanaging this risk. There's one exception, and the exception is that they didn't position themselves at the discount window ahead of time because the Fed discouraged it. Bill Nelson, who was a former Federal Reserve staffer who oversaw a lot of the discount window for 25 years that he was there, tells the story that a New York bank treasurer is hired, and the treasurer inside a bank is meant to manage liquidity. Right, works for the CFO, works closely, just making sure that the bank has the liquidity available to do all kinds of things. And he said, the minute that you use the New York Fed's discount window, you're going to get two immediate phone calls. The first is from the president of the New York Fed asking why on earth you're using the discount window. And the second is from the head of HR telling you to clear out your desk, you've been fired. And so the idea is that the discount window has a stigma. The Fed sometimes complains in a crisis about that stigma, but the Fed is responsible for that stigma. And so that fact creates real tension. Whether the Federal Home Loan Banks, I have no idea what we should do with that mess. I've spent the last 15 years really focused on the governance of the Federal Reserve System. After I've published this book shortly, I'm probably going to change tacks so I can just I can do other things in financial history and financial policy. But I'm intimidated by the Federal Home Loan Banks because, as messy as the reserve banks are, there's at least an ethos, right, that I can understand, a history that's rooted. The Federal Home Loan Banks are the beach ball in the wind. I do not know what purpose they are supposed to serve when events have so completely overtaken them. For example, the initial liquidity they were supposed to provide has almost been completely displaced by Fannie and Freddie, that have bought up these 30-year mortgages and then issued their own securities, which are now the absolute backbone of the U.S. mortgage market. So Federal Home Loan Banks are then what? There's like lending, but for what? What purpose? I don't have an answer for that. I don't think they have an answer for that, and it's kind of an alarming question.
Yes, well, in terms of the challenges that poses, in terms of the the project you're talking about, looking into to central bank history as well. My colleague, Professor Fortin, asks whether, as a legal historian, you find it difficult to access internal primary sources relating to the Fed for reasons of national security, privileged information, and so on. If so, what kind of information are we missing that would complement our current state of knowledge about the Fed's use of its vast discretionary powers today, and I guess historically as well?
Yeah, wow, what a great question. You know, I'm a financial historian at a business school, and sometimes when I talk to legal historians at law schools who are dealing with the work of courts and lawyers, we have opposite problems. Their documentary record is overwhelming, right? They have just so many, you know, briefs and decisions, especially for the intellectual history side of legal history. Socio-legal history is harder, for sure, and they have a documentary problem, especially the further back you go. But my problem is that while we are choking on data, there is a leaden blanket that descends on any conversation that occurs behind closed doors, and those are the only conversations that really matter. There's even a legal architecture that the Fed and the banks have developed that I think is bogus. In fact, I have in mind to write a law review article about this, but because I just think it's just wrong top to bottom. But the label is confidential supervisory information, and it's not a complete naked power grab to wrap all of this in secrecy. Congress has authorized it in two places. So the first is a bank examiner that discloses confidential supervisory information in specific ways of specific kinds can be prosecuted. So that's the first idea. But that doesn't tell you anything about what the banks can disclose. And the government has said that banks don't get to disclose confidential supervisory information, which I think is wrong. And the second is that there's an exemption 8 in the Freedom of Information Act, or FOIA, that precludes the disclosure of examination materials through FOIA. Now, that doesn't tell us anything about the disclosure by the government of confidential supervisory information, not the bank examiners. Doesn't tell us anything about the bank's disclosures. And I think, in my own experience, losing a tremendous number of FOIA requests from the banking agencies, I will say that they interpret that provision so broadly that there's no way it would hold up in a court of law. But it's never been tested because I don't know why. I just don't know if there are people who are motivated enough to sue. Now, actually, that's not true. It has been tested, and the Fed has lost. A really famous example of that. There was the Bloomberg and Fox News during the financial crisis FOIA'd the identity of some of the participants in the emergency lending facilities, and the Fed denied it on Exemption 8, and the news agency sued, and they won in the Second Circuit. And so that was so much of what we know about the 2008 crisis. We know because the Fed overplayed its hand on its claims. So it's a major problem. Sean Venata and I, in writing these articles, we have another article that was published in the Business History Review about the 1933 banking holiday, which was a major turning point in the practice of bank supervision in the U.S. All of our primary sources we either have are by hook or by crook. Like one we found in a forgotten box in the National Archives that contained a lot of examination reports. We pulled them, we read them, scanned them, got them, and then they immediately were reclassified. So future scholars are not going to be able to see that. Sometimes in congressional hearings, they'll disclose examination reports, and so once they're there forever. So we've gotten those. But we've had to shadow box a little bit with this history because the most important documents that we want to see, we can't see. And that's a real problem. It's not because they don't exist, it's because they exist, but they're wrapped in this shroud of secrecy. I've had conversations at very high levels of government to work at a better system of this. They were reaching a really phenomenal place where the Fed was about to make a big announcement on March 5th or 10th or something, I can't remember. And then they delayed it because of the banking crisis. Boiled again, maybe one day.
Next time. On a similar theme, Christian Flores asks, what are the overarching differences between the way economists, lawyers, and historians view the Fed and central banking policy? You've talked about listening to legal historians, legal scholars talking about their challenges. What do economists and historians, who are historians? Well, you're a historian.
I'm a
So
historian, yeah.
you're a historian. So you
I
have
mean, yeah, sorry.
so you have your view, but then the economists and the lawyers, what are the key differences between how you view the Fed and policy?
These are just such great questions. So to give a kind of a sense of my own disciplinary commitments, so I'm a legal scholar, so I'm very active as a scholar in writing about current topics in financial regulation. And I'm a financial historian at a business school where 90% of my colleagues are economists. So while I'm not an economist, I co-author with economists, and I'm my co-director of the Wharton Initiative on Financial Policy and Regulation is an economist, Itai Goldstein. I'm in those rooms all the time. And the other additional disciplinary category, which I don't belong but spend a lot of time with, are the bankers themselves, who are pretty active in this space, and they see this so totally differently. Lawyers think a lot about institutions. Legal scholars think a lot about norms and practices and relationships across institutional divides. They care an awful lot about the identity of policymakers, and look a lot at the relationships between rules that the Fed announces when it blames or credits the law. Legal scholars tend to think about that as strategic exercise rather than as just an exercise in legal formalism. Economists just don't tend to think about those issues much at all. And that's too broad a brush. There's some, I mean, Itai, my co-director, he thinks about these issues all the time. He's really immersed in those kinds of details, but he's a little bit exceptional. And so most of the conversations are, when you assert institutional importance with an economist, they'll, if they're motivated to put you through your paces, they'll ask you, compared to what's a counterfactual? So you think that J. Powell matters so much. Well, if he had been, if instead of J. Powell, it had been Lael Brainerd, what would be different about today? And historians tend to have an allergic reaction to counterfactuals, but I'm with the economists on this. Even though you can't answer the question, you still have to think about its importance to your own causal conclusions. And so historians tend to eschew counterfactuals. Economists tend to embrace them. And that makes for a really important dialogue when it can occur, and it makes for a siloization where it doesn't. And legal scholars, so historians are also really focused. I'll be really clear. I don't spend, since my PhD, I haven't spent a lot of time in a history department, and that's in part because I'm at a business school and I've got other just demands on the time. But in part, it's epistemological. History departments today, there's just not a lot of interest in financial history and institutional history. And so a lot of the ways that the historians might think about the Fed would be to put the Fed in dialogue for other kinds of questions of social and cultural history. And so if you see central banks as the end of the conversation, like you want to understand it for its own sake because you take for granted that it exercises enormous power over the system, then you're not going to have a lot of interlocutors in the history profession. And so these differences, I think, are pretty rich and interesting. And when they happen well, you have a very diverse, quite lovely chorus of dialogue. Where it doesn't happen well, which I think is the median case, it's cacophony, and it just doesn't happen. I mean, just people just don't talk to each other. But I think our experience with WIFPR, as we call it, the center I co-direct, we are seeing real successes where we're bringing central bankers and economists and historians and legal scholars together, and we're saying we got to have one conversation. Here's the level of abstraction where all can participate. Now bring in your disciplinary perspectives, but have the conversation at that level of abstraction. And it's been pretty successful, but it takes a huge amount of work.
Speaking of conversations and bringing central bankers and lawyers in particular into conversation, and this is the theme that we'll wrap up the discussion on. You referred on a number of occasions to decisions being taken behind closed doors, which leads in particular to a danger of groupthink. Groupthink is always a danger when groups make decisions, but when groups are making decisions in secret, there aren't any checks on what the group is deciding, or the checks are harder to implement. But one of the core values of administrative law, as it has developed over the last century at least, is transparency, openness, participation, deliberation with inputs. What future for an administrative law of central banking? To what extent would that alleviate some of the difficulties that that have arisen, and how realistic is it as a prospect?
Now you're touching on the article that I wrote with Nick Perillo and Yair Listikin. Nick is my favorite administrative law scholar. I just read everything he writes, even though I don't, I do less and less with administrative law. But we wrote this article because we'd been having some conversations, what Nick had called our trans-substantive discussions of administrative law, and where we were just sort of teaching each other about these worlds. I'd clerked on the DC circuit, and so I was not ignorant of these issues, but seeing the world through his eyes on the conversations in the 21st century about where administrative legal scholarship had veered, and where in Nick's case, he's done some massive research projects about current administrative practices, were incredible to me, rooted as I am in the central banking tradition, because the Fed has a dissociative identity relationally to transparency. Beginning in the 1990s, there was a revolution in transparency. At the time, the Fed didn't even announce what policy it had made. It left to the markets to discern it based on market activity. In 1994, there was a big controversy here, where members of Congress had discovered that the Fed was recording its meetings, something that not even all Fed participants knew. And this launched a transparency revolution on monetary policy. Now, at the time, there was nothing from the Fed. There was no Fed website. The web was still pretty inchoate. There were no press releases or press conferences. Again, there's no even announcement of Fed policy. That changes in 1994. And for the next 14 years, that's the only change. You get also a 5-year lag on release of transcripts, and then an extended lag. I think initially it was 10 weeks, and now it's 2 weeks on the minutes. And then in 2008, Ben Bernanke institutes a press conference every other FOMC meeting. Now, this is breathtaking. Let me read to you the entire press conference in 1932 of then Governor Eugene Meyer. Who said, they were having a meeting. This is in the height of the Depression and banking crises. So it was of great public importance to know what the Fed was doing. The reporter says, "Will you finish today, Governor?" Talking to Eugene Meyer, who is what we now call the Fed chair, but was then called the Fed governor. "That depends on whether we conclude our discussions today. If we do, we will finish." Reporter, "Could you say what the subjects are under consideration?" Meyer, "Why, almost everything." And the press conference concluded. So they wrapped themselves in opacity. And then we have, a couple weeks ago, a major press conference, which is the standard now, every single FOMC meeting, where Jay Powell is put through his paces by reporters and tries to give as thorough answers as he can. We also have a summary of economic projections, the so-called dot plots, where we get to see the Fed thinking in real time, missing projections. So they've never got one right, which is tells you something about what the exercise is. It's not an actual exercise in projections. It's an exercise in transparency. and then compare that to the Fed's supervisory apparatus and its crisis fighting. To this day, on April 4th, we have no idea why the Fed declared a financial crisis with Silicon Valley Bank. Why did it create the so-called 13.3 facility for exclusively bank lending when that's what the discount window is for? When asked about this in his press conference, he said, oh, there's no magic to this, so we just thought it would work better. Totally inadequate. We have no sense of it. And this article with Nick and Yair, we wrote that the Fed needs to, the different parts of the Fed need to be in conversation with each other. And we focused on supervision and crisis fighting in relation to monetary policy, which has been quite transparent. We had recommendations that we called the article Towards an Administrative Law, because we recognize that there are really important differences. You can't simply have APA notice and comment rulemaking for bank supervision. That's not what supervision is. That's not what makes it special or effective. But you can have more than what we do have. So we recommended, and we wrote this before the pandemic, but it was published after. And so we got to revise a little bit to think about how this would relate to pandemic emergency lending. Our basic recommendations, the Fed just needed to explain itself more. It needed to give more legal reasoning. It needed to have that legal reasoning tested, because it's making real commitments of public credibility and public resources on the basis of legal theories that are sometimes quite strained. And it would not do the same thing with its monetary policy. It is very transparent and an open dialogue with whether it's getting it right or wrong. It doesn't do the same thing with its administrative law. And we think it should do more. So I would like to say that we are moving in the right direction, but the 2023 crisis tells me that we're not. I have no idea whether or not the Fed's lawyers will get this religion and see that they are thinking about their legal relationship to the Fed the way that a private lawyer thinks about its relationship to a private institution, and it's not appropriate for a central bank.
Now, there is a good discussion in your book of the legal interpretation that underpinned the restrained interpretation that underpinned the refusal to bail out Lehman Brothers in 2008. Just one very last question for you before we end, and it's about again about transparency. One of the things that struck me, I was reading Adam Tooze, the Columbia financial historian, on the pandemic and on the financial crisis. And one of the things that struck me was, which I never really understood, was the extent to which the Fed, by creating dollar swap lines with central banks around the world, helped to prop up flailing economies. Hugely consequential decisions, not just for the United States, but internationally. And something about which very little was known, as far as I can tell, and that maybe just underscores the extent to which the Fed exercises extraordinary powers, and that more transparency would perhaps be desirable.
Yeah, the international swap lines have such a phenomenally interesting history. Starting in the 1960s, but going back earlier, I mean, much of the Depression, the criticism from Congress during the Depression was that the Fed was paying too much attention to its support of the Bank of England and too little to the support of the domestic economy. This gave rise to Glass-Steagall, because there's a direct connection between the idea that the Fed was sponsoring speculation by encouraging banks to dabble in foreign securities, and that they had so many arguments and ideas about how to restrain this speculation, and then ultimately decided, somewhat against Carter Glass's instincts, to make that the problem of the private banks by dividing them up so that speculative investment banking just would not be exposed to commercial banks at all. The fear of speculation was oversold. The support for the Bank of England was meant to, under the existing framework of the time, to which even Roosevelt and virtually everybody ascribed, was support of the gold standard. And so the support of the Bank of England was entirely selfish from that perspective. And then, that commitment to an international financial order continued apace. We had a big intervention in 1961, so-called Operation Twist, where the Fed engaged in what we would now call swap lines in the 1990s to circumvent congressional restrictions on the Treasury's support of the peso and other international crises. The Fed stepped in with international swap lines of dubious legality, and then again in 2008, 2020, and then and now we have a standing facility open for central bank demand of dollars. The legality here is again, it's consistent with the critique from me and Nick and Yair that the Fed needs to explain itself better. Then it needs to open up its legal analysis to scrutiny, and needs to tell us more about what it is that it thinks it can do and can't do with respect to these facilities. The policy perspective, I think, is hard, and here's my perspective on it. We have what has been called the exorbitant privilege of having the international reserve currency. Dollar dominance serves enormously nationalistic purposes and redounds to the benefit of the United States. It also permits us to be reckless in conversations about the public fisc. The so-called debt limit is our exhibits A through Z on that score. But it's a benefit that every country would want, and only, generally speaking, one country can have. And if you're going to do this, then you have to provide some sort of financial stabilizing availability of dollars throughout the world. And so from a policy perspective, this is kind of what you want a central bank to be if you've got an international reserve currency. And if you don't, then that's a different kind of problem. But still, for now, we do. And despite China and Russia and Brazil's efforts to move away from this, so long as we have the international reserve currency, then we've got to make it available in times of scarcity, and that's what these facilities are meant to do. In a different article that I wrote with David Zering called "The Foreign Affairs of the Federal Reserve," we think, because of this tension, this is legally dubious, but from a policy perspective is quite good. We think that the Fed needs to hear explain itself too. So we would favor a semi-annual testimony about the Fed's international activities, not because we think that they should be prohibited, but because they should be explained. Now, the Fed has made no effort to do this for good reason, and so we'll see what happens from there.
Well, thank you very much, Peter, for that answer, and indeed for all of your answers. If I may be so bold, it's been an exorbitant privilege to have you with us. It's been a fascinating discussion. I posted a link to Peter's SSRN page in the chat, and that's well worth looking at. The book, which sparked my interest and so intrigued me, is The Power and Independence of the Federal Reserve from 2016, but still as relevant today, if not more so than it was in 2016. So it only remains for me to thank you, Peter, for your time this morning, this afternoon. It's been a real pleasure and very enlightening and thought-provoking discussion about central banks.
Thank you so much, Paul. I was so glad to be with you.
Thanks a lot. Bye, everybody.